did it say?
It said that separate but equal facilities were consistent with the Equal Protection Clause.
Okay, now that's in 1896. And do you know, are you familiar with Justice Henry Billings Brown?
I feel as though I should be, but I'm going to say no.
Well, you don't want him to be your hero, trust me. Here's what he said in 1896. We consider the underlying fallacy of the plaintiff's argument too consistent in the assumption that the enforced separation of the two races stamps the colored race with a badge of inferiority. If this be so, it is not by reason of anything found in the Act, but solely because the colored race chooses to put that construction upon it. Now that was the majority holding, one of the holdings, and it didn't change until 1954. So to conservatives and liberals alike who believe that precedent can never change a case, this is a good example where I think we're all glad the case changed. Because this is what happened in 1954-55. Justice Warren. To separate them from others of similar age and qualifications solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. Whatever may have been the extent of psychological knowledge at the time of Plessy versus Ferguson, this finding is amply supported by modern authority. So if you could, this could be a little bit of a teaching moment. Nothing changed in the Constitution word-wise, did it?
It did not.
So it's the same words, looked at 50-something years apart, with a different conclusion. How could the court do that and be consistent with strict constructionism?
Well, Senator Graham, I guess a couple of things. The words of the Constitution did not change, but two things did change. The precedents changed, and understandings and circumstances in the world changed. So the precedents clearly did change. Brown was not a thunderbolt from the blue.
It was the last in a line of decisions, right?
It was the last in a long line of decisions, and one of Justice Thurgood Marshall's, his greatest accomplishment, was to lead up to Brown, step by step by step, case by case by case. As an advocate, of course, you can have a strategy like that, and he did. And by the time the court got to Brown, upholding Plessy actually would have been inconsistent with a series of other holdings that it had reached over the years. And I do think that that sometimes happens in constitutional interpretation. And it also happens, I mean, we've talked a lot about the doctrine of precedent and about one reason to reverse a decision is when its doctrinal support has been completely eroded. And I think that that is what happened in Brown, that by the time the court reached Brown...
And I think most Americans, if not universal, as close to universal as we'll ever get as a nation, glad it happened in this case.